Right.
Morning, sir. Are we well?
Yes, fine, thank you.
Excellent, excellent. Well, we have a good list of people on board. We've had over 450 people register for this webinar series now, which is really good, I'm pleased to say. I don't know why. What a boring subject. Not really. You guys love it, don't you? Okay, right. Well, let's get this show on the road. So the first thing that we're going to do is we're firstly very quickly introduce ourselves, and then we'll get straight down to business. Obviously, the title of today's webinar is Marketing Data, Brexit, UK GDPR, EU US Privacy Shield in 2021. Wow, what a mouthful. But actually, you know, that's quite. Granted, it sounds like a really dry and really boring subject, and our job today is to make sure that that's just not the case, because I don't listen to webinars that are boring. You know, somebody said to me a couple of weeks ago, they said, don't you find that people are webinared out now? You know, they're on webinars for everything these days. I said, no, they're not. They're bored of crap webinars. They don't want to sit and listen to boring stuff. So let's just try not to make this boring. Let's make it fitting for the people. So very quickly, my introduction. I'm Adam Oldfield. I'm the Managing Director of Force24. We're a marketing automation platform based right here in the UK. We're one of the few UK organizations. We have nearly 5,000 users using our platform every single day. That's marketeers, just like you guys, all of them who care about their data, care about the relationships they hold with their customers. And if you are using marketing automation, want to use marketing automation better, whatever, we give free training. Where is it? It's mirrored. Free training and support for life for all of our customers. Please come and say hello on our website, force24.com, and book a demo. That's more important. So, Philip, do you want to introduce yourself, and then Paul? Philip, first.
Thank you very much. My name's Philip Allott. I'm the Managing Director of Allott & Associates. We're an international agency, and one of our services is data protection, and you can outsource your data protection to ourselves, as indeed Force24 does, or you can buy our time on a ad hoc basis.
Thank you very much, Philip. And Paul.
Yes, so I'm Paul Berwin from Berwin Solicitors. We're in Leeds and Harrogate, but we've got specifically specialism in advising technology businesses in Leeds, so that's things like data protection, like IT contracts, like intellectual property, all those kind of things.
And not to lower the tone, had a really great radio jingle as well. I can't remember how it went now, but I always mention it. Anyway, so let's get on with it. Let's have a quick recap on Privacy Shield. So for those of you that have been on this the previous webinars about this topic, we've had a couple of on this particular topic now. We just want to keep it really quickly condensed. So I'll just give it a quick run through, and then we'll go through the updates and we'll start talking about the agenda that we've got lined out. So the first thing, I believe it was July the 16th this year, the European Court of Justice deemed the Privacy Shield, which is the legal framework that you guys are using right now, or were using pre-2016, to send data to North America, is invalid. You cannot use it anymore, which means that if we are shipping data of European subjects, personal data of European subjects, names, addresses, email addresses, whatever it may be, it doesn't matter if people say, well, we're B2B, it's all the same. We're shipping that data to North America, we're breaking the law unless we do certain things, and we can cover off some of those certain things in just a moment. The general feeling is, and we've been, like I said, I don't want to spend too long on this, but the general consensus is that the European Union's data protection rules do not deem North America adequate. And in essence, really, North America and China, in terms of their data policies, are probably not that far apart from one another. And we've been through, we had a great chat about this. Shut up, Siri, that's got nothing to do with you. So is there anything before we move on from that quick update? Paul, is there anything that you want to say quickly about what happened with the Privacy Shield demise?
Just specifically, it's the United States, it's not Canada, very specifically not Canada. So
Yeah.
it's the United States that it affects, and it's because
Which-
of
It's the world. Basically, everything is based in North America. Tech world is based in North America. And it annoys me to hear that, but it is. So it's a big problem, right?
yeah, and there are transatlantic cables, and the US government have the right to intercept data passing through those cables.
Oh my God. Didn't know that bit. Fun fact for you there. Good. Okay. So so we know that that was the situation. That's not good. And then on the last webinars, we've talked about ways that you can mitigate that. Obviously, one way, use Force 24, don't ship the data out to North America. But there are obviously other things that we can do to mitigate that. So Philip, do you want to quickly give us the quick rundown on what an SCC is?
Okay, SCC stands for Standard Contract Clauses. It's a document drawn up by the EU. The problem is with the document is that it is an EU document, and we are not part of the EU anymore. And after the Brexit transition arrangements at the end of this year, the Information Commissioner's Office will need to determine whether a new document's needed, and we're still waiting for guidance on that. So the situation at the moment, if you want to ship data to the United States, Canada is fine. It meets the standards of adequacy, but the United States doesn't. So if you want to ship stuff there, you need to complete standard contract clauses. These are binding on both parties. They're pre-written by the EU. You simply put your details in at one end, and the person who's carrying out the processing completes the other side. If you have a subsidiary in the UK and head office in America, and I do some work for American companies, and they get quite tetchy about their staff, and they expect personnel records and information shipped over there. You cannot do that unless you put in place binding corporate regulations. And if you don't have those in place, then you cannot ship that data. If you choose to ship it, then there is a risk you will meet with a fine, or alternatively, somebody will take a civil class action against you.
Yeah, so just had a question just come through actually, which is quite interesting. Just quickly defining on personal data, and I think this is something we always have to. It doesn't matter, you know, in GDPR we had this situation, post GDPR we had this situation, classified personal data. So Philip, do you want to give me your definition of what personal data actually is?
So personal data has been defined, and this is by the courts. Even an IP address can be defined as personal data. So an email address, philip.allott, for example, is personal data. If you put PDA at Force 24, that's okay. But if you put your full name, then that can be deemed personal data. Obviously, anybody who's got Gmail accounts, etc., with full names in, again, personal data. Your address, your driving license number, your passport number, any personal information about you. If you choose to have details of your children, that's personal data. You cannot ship that kind of thing.
So just quickly on that point. Oh, by the way, some of you are using the chat and some of you are using questions and answers. Could we use question and answers? And then it's fine for the ones that have gone in there. It's fine. Amanda and Andrew, that's absolutely fine. We'll sort those. But if you can use the Q&A, that'd be very much appreciated. But so baz74@hotmail.com. That's not my email address, but is that personal data?
It's difficult. Can you identify a data subject from that? You possibly can't, and that's fine. But what about the IP address? Can the IP address be picked up or not? It depends if it's bouncing off a Google server or not.
So the common use case is I have got adam.oldfield@force24.co.uk. That is personal data.
It's both corporate data and, in your case, personal data.
Fine. Okay, so we understand that. And one of the questions as well, I'm not going to do the questions right now, but you're just goading me with these questions. They're brilliant. And the one here is, so Salesforce database, the Marketo database. Yes, that's what we're talking about. And actually, Paul, let's come on to this. So actually, when we're talking about the definition of what shipping is, so I don't physically put a CD on a ship and I send it out to North America. But what I don't realize is Salesforce, for example, may have a data center in North America, may have one in Europe, may have, all over the world. But that's not necessarily enough, because a Salesforce representative based in San Fernando Valley logs in and has a look to debug something on your account, ships that data on your behalf back to North America, for which you are liable. So Paul, do you want to expand upon that concept of shipping data?
Yeah, that's right. So it could be in all sorts of ways. So the data that's on servers in in the EU or in the UK might be mirrored in the US. It might be accessed from the US, and as long as it's being accessed from the US for maintenance purposes or for analytical purposes, whatever it is, that is a degree of processing. So that does mean that you've exported that data for that purpose. So sometimes it can be quite slight, sometimes it can be a lot more major.
Okay, so what we're saying is that shipping data is me sitting in North America, looking at a screen, even if the data's in Europe, looking at a screen. That process has sent that data through the cables under the sea or through the satellites to the North American shores. And I know this sounds really picky and really, oh my God, this is like driving at 71 miles an hour down the motorway. But the problem is, when you're driving at 71 miles an hour down the motorway and you have a crash, you're in a lot of trouble because you were breaking the law. And that's the problem that we've got here. So whilst this is, okay, that seems really minor, actually, is it? And that's the question. So
can I just chip in there, Adam? It's more fundamental. Yeah. So supposing that United States company has actually got a server in London, can they meet adequacy? Well, actually, possibly not, because the laws in America say that American companies or United States companies have to share data with the state if deemed necessary. So that means if they're US subjects who are working in the UK, then that data, they have to make that data available to the US. That's the law in the US. So even if it's on a Microsoft server in the south of England, which they have, or east of England or wherever, the Microsoft personnel in America can actually tap in there, look at that data, and that data is of UK subjects.
Okay, so again, I'm going to move off this because it does feel like we're hounding a point, and I don't want it to feel like that. I want this to be about the facts, and actually, the final point that I would make on this is, I want you to just think for a moment as individuals sat at home. Would you share your data willingly share your name and phone number with China? So an organization with China, we know that China is a communist run state. So we're not, the data within China belongs to the Chinese government. That's the rules. That's how it is. Belongs to the government. It doesn't belong to, as soon as it lands on their shores, it's their data, and not yours anymore. Well, it still is in some respects, but anyway, the point is, would you feel comfortable doing that? And the answer, or okay, would you feel comfortable sending it to Somalia? Would you feel comfortable sending it to, anywhere where you don't believe that the data privacy law? Well, actually, forget the data privacy laws. I just don't know much about it. I just don't fancy doing it. And the point is that actually, when we look at it, the USA and strangely enough, Australia, our Aussie mates, their data protection laws are even more relaxed, aren't they? Isn't it something you were telling us the other day, actually, Paul? It was actually they're worse.
Yes, they're definitely on an American line. They're not on a Canadian EU kind of line. So you would expect that they would be, but they're not at all. Okay.
All right. So binding corporate regulations, rules or regulations, BCRs.
Rules.
Okay, so Andrew has said also BCRs are very complicated and take a long time. What happens during in the interim before it gets set up? Well, before we do it, let's just wow the audience with your fact. How many companies have registered BCRs?
Since 2005, 15 years, there are only 35 sets of binding corporate rules have been approved by the ICO, and they take a minimum of a year to be registered. It's not an easy course, and if you can see the companies who have registered, they're major corporations with massive resources. It's not a panacea at all.
Okay, so it's a mess out there, and that's kind of scary. So that's what we do know. The SCCs, basically, it's fine to use them if you've got the SCCs in place, and you can do that. But yeah, it's fine for the big providers. The big providers seem to take it upon themselves to develop these work with these SCCs and push it out. But the point is, here's the sucker: the SCCs still are gonna be pulled down, because the fundamental that Safe Harbor fell down in 2016, Privacy Shield fell down in 2020, SCCs, because fundamentally in the European Union, we have rights as data subjects. In North America, those rights are not respected. Therefore, it doesn't matter what legal framework you have, they're not respected, so they will be written down. Written down. And that's the most important thing, that over the course of time, this is getting more and more of a tight noose around the neck of North American businesses. And the European Union are essentially saying, get over here, run these business units over here as total business objects. Philip, you were telling us Microsoft have pretty much started to do this already, and they're probably a lot further forward than most. But it's more the smaller companies where you're shipping your data out. I don't know, your smaller companies where you're using them for email or something like that. And it's not a big company. And do you know if you've got big SCC? I don't know. Well, you haven't, is the simple point, if you don't know. Okay, so on that, guys, have we got any updates since the last time we run this webinar? Has there been, I know that Max Schrem's organization has registered 101 cases. So Paul, that was your little factoid. Do you want to elaborate on that?
Yes, so I'll just put the web address into I'll put them into the Q&A actually. So Max Schrem's the guy in whose name the action was taken, that the July decision was made on. So he has an organisation called None of Your Business, noyb.eu, so. Just 1 second. So after the decision was made, a short time afterwards, they filed 101 complaints, and on their website, which I haven't put up yet, but on their website, there's pictures of Dalmatians, 101 Dalmatians, of course, and they filed those against all of the member states and against a large number of US corporations, because when the decision was made by the court, it became binding immediately. No transition period, no sunset period, anything of that sort. So they filed all those complaints. They say the only people who've done anything, who've taken action to respond to those complaints, are 3 companies, or 2 companies and 1 government, and they're all in Liechtenstein, and therefore not really major to the whole set of things. Of the companies, most companies like Airbnb and Google and so on haven't responded. Microsoft again are kind of the good boys in this. They have responded pretty constructively. NOYB are reasonably pleased with the direction they're going in, but there's court action going on all over the place. So this isn't just, oh, it's illegal, but nothing's going to happen. It is happening.
You know, and it's Max Schrem that is not going to rest. You know, because what's happening is, as soon as this happens, the big boys say, yeah, but we can have SCCs. Not for long you can't, because the underlying principle is it's not fair. I gave you my data in the UK. I live in this. So we'll talk about Brexit next. That's our next thing. I gave you my data to a UK business under the regime and the rules in which we live under, which the ICO presides over. And that's why I gave you my data. You then saw it fit to ship that data to another territory outside of the territory in which is data sovereignty, outside of the territory in which I gave it to you. And those rules, you haven't checked them, you don't know anything about them. You're just happy with the fact that my data lives over there somewhere. And that's the problem. And that's why SCC's short-term response, what ultimately needs to happen is these business units within this country. But then, Philip, your point that they can still start pulling the data apart from North America anyway. Anyway, let's
Adam,
move on.
it's worth saying the European Court of Justice ruled that even if Facebook had standard contract clauses, they would still not be valid. That's quite a departure for the court to actually say that. So effectively what the court's saying, even if you're relying on standard contract clauses, they're not necessarily going to stand up to scrutiny.
Well, that's okay. Well, I was going to move straight on to Brexit, but I'm not. I'm going to move on to a point that one of you guys made earlier on, which was the ICO have created an interactive tool, right? So the ICO have created an interactive tool for you to create your SCCs. You have to get whoever it is to sign those SCCs. Good luck with that with MailChimp or whoever it is.
Yeah.
But you have to, so you can go onto the ICO's website. And I'm sure, Rory, if you can Google this or you can find the URL, we can probably put it in the chat. You can go onto the ICO's website and you can create the SCCs. You can sign your copy and get whoever it is to sign the other copy. But get this, there is a new SCC that's being released by the end of the year. And that new SCC will not cover the United States and Australia. So that's an interesting revelation, isn't it? Why the hell not? I mean, do you have any insight as to why they've not going to cover the United States and Australia? Is it because they see the writing on the wall, or what? What's the angle there? Philip, have you got a clue?
Well, I think that the problem is with Australia is it's quite Dickensian with data protection. So although they have data protection legislation in place, fairly elderly act actually, the difficulty is that the states see it as a means of protecting Australia rather than protecting consumers and individuals, which is diametrically opposed to what the EU and indeed the UK want to achieve. So in such circumstances, when you've got the Australian state turning around and saying, we want to decrypt things like WhatsApp, which as we all know is encrypted, so our spooks can have a look and see what's going on. How on earth can you rely on sending data there no matter what anybody signed up to? That's the problem.
Joe Schmo within the organization has signed. Yeah, we signed to say that the government can't do this. We can't do that.
Absolutely.
So look, let's move on. Well, let's talk about Brexit. My second most least favorite subject in the world next to pandemics. So Brexit, we know what's happening. We know that, and actually not a lot of people do realize we left the European Union. We've left, it's gone. We're not a part of it. We have, however, been within a transition period. Now, I think most people think that we leave on the 31st of December. It's the 31st of December, by the way, not the 1st of January. We don't. We've already left. The transition period of which you were supposed to be doing stuff was now. And then the deadline is the 31st of December. Now, the frustrating part about that, as you guys sat there with literally no information to act upon, what are you supposed to do? So the government has left us, granted pandemics in the middle. I get that probably wasn't the best thing for Brexit negotiations. But then again, at the same time, we have been sat there with grey areas. And so one of those grey areas is, well, I tell you what, let's not talk about that yet. We'll come on to that. One of those things that is not a grey area is, will the GDPR be written into UK law? And Philip, do you want to take that one first? Because we already know the answer to that one. So do you want to take that one first?
Yeah. So what we do know is that the UK actually has two pieces of legislation. So we have the EU regulations, which are read directly into English law without the need to enact anything further. We also have the Data Protection Act 2018, which covers security service, police, etc., and certain state activities. So what the government is doing is merging the 2018 Data Protection Act with the EU GDPR to create UK GDPR, and that will be rolled out in the new year. But that has to be enacted into domestic law. There's some clever ways that Parliament's doing to actually be able to do that very quickly, and that will become the new playing field next year. Will predominantly be exactly as GDPR is now in the UK, but there will be some subtle changes to that. We're not entirely clear, even at this stage, what those will be, but it will be predominantly the same. So if you have, in summary, if you already have a GDPR policy, privacy notice, things like that, documentation in place, then the idea is that that documentation will continue pretty much the same, although you will need to start renaming things.
Okay, and so are we saying that this is yet to happen and it might not be done by the 31st of December, or are we saying no, that's happened, it's fact?
So Adam, there are some things we don't know. So one of the things we don't know, and Paul and I and most people are all waiting with bated breath, is to see whether the United Kingdom meets something called adequacy. That is a safe place for EU data to come into the UK, because if we don't have that, no matter what we do in the UK, there will be issues importing data from anywhere within in the EU. So that's the first thing. So we don't know that. Secondly, we're also not entirely sure what the final format of that legislation will be. We think we know what it is, but if there's anything that's been uncertain during the last 5 years, it's how Parliament reacts to legislation. I mean, it took us quite a number of years just to actually get the relevant legislation through so we could leave. So nothing is a given, and I think there will be lots of unknowns when we start the new year.
Okay, so, but perhaps the ICO have already got in front here. So perhaps the ICO's interactive tool is to say, look, just in case the UK adequacy decision either does not go our way or does not happen quick enough, businesses with holding in the UK, holding and processing European data that was collected on European soil, not British soil. And I'll come on to that in a second, the differentiation between collecting data on outside of the territory and shipping it outside of the territory. But maybe the ICO has already said, look, you know what, we're going to look after our own first, and we're going to build an interactive tool that says UK companies wishing to deal with European companies and hold their data, we're going to build this interactive tool so they can output the SCCs. Does that make sense? Is that likely what they've done?
It's quite possible. I mean, the other thing that companies are moving towards, particularly Ireland's benefiting from this, is companies in the UK registering an entity within another EU country, i.e. Ireland and the Netherlands, to hedge the bet, so they can actually effectively have EU representation after the 31st of December. Part of that is for data protection purposes.
Okay, so let's now just draw up an important differentiation for a second. I want to just run a scenario, and Paul, let's run this past you first. And the scenario is, I'm a UK company. Doesn't matter where in the UK. I'm a UK company. I have a website, and we sell widgets all over Europe. Okay, so Mr. Francois from France comes onto my website and submits his details into my website. Paul, do I have an issue here with that?
Well, he then is not he's not a UK citizen. He's an EU citizen, a French citizen, and what matters is where he is really. So if you're likely to be doing that, then it seems as if you should have an EU representative. I just was checking that today, and I think that's the case. So you're going to need an EU representative who upholds the rights, so to speak, of EU citizens when transferring data to the UK.
Hold on just a second. The differentiation is the data isn't being transferred to the UK, it's being collected in the UK by an EU citizen. So I'm a UK business. I have a website. People from the EU can access that UK website and submit their data into that website.
Right.
And buy and sell.
So we're transferring data effectively from the UK to the EU, or a citizen in the EU?
No, a citizen in the EU is
Right.
buying from me in the UK. There's difference to me. I'm collecting the data in the UK, essentially, of an EU citizen.
Right. So as between those organisations, you should have SCCs, just to be sure. I'm not entirely sure what the issue is going to be there. Philip, what do you think there?
Do you want? We can
So I
talk about.
I think it's just the premise of the question, Adam. So I think so
Yeah,
you're
sorry.
saying the data's from say France, and it's coming into the UK, but the person processing it over here is a French subject. Is that what we're saying?
No, I've gone all over the place with this. Right, let's rephrase this. I'm a British company, right? And I've got a website that is stored here, and it says, "Hi, welcome to my widget company. I'm based in England, and I sell widgets." The server is based in England. Make sure you know that. And then my friend Francois from France is a normal bloke. He's not got a business. He comes onto my website and says, "Oh, I'll have some of those widgets." Gives me his name, gives me his address, and buys some widgets from me. So I, as a UK company, I'm now going to store that EU citizens' data in the UK pre-adequacy decision. Have we got a problem, or is that fine?
I think you've no problem. So one of the key things is transparency with all these things. So you've been transparent that you're a UK company, and I hope you'd have, and if you haven't, you need to do it. Make sure your privacy policy or privacy notice says in there that you store that data in the UK. Therefore, your French friend, when he buys, will be able to look at your privacy policy if he's so inclined and see that his data will be stored on a server in the UK. If you do all those things and you're transparent, not a problem. If you do them in secret, there will be problems.
I suppose the issue there for a lot of companies, and we spend a lot of time just looking at people's privacy policies, a lot of companies have just very generic privacy policies. They're not specific to what they're actually doing. So one of the key things people should do is make sure their privacy policies are actually current, and that they are not just an off-the-shelf thing that sometimes their privacy policy is a web developer sort of said, "Oh, there's a privacy policy, use that," and it's not specific to what the company is doing. So as long as it's specific to what the company is doing, it gives that information, so it's transparent what's being done with the data and so on, and where it's being held. Then, as Philip says, then that's the key thing that you need to be doing there.
Okay, all right, fine. So where I was wanting to get to is that I think the point is that disclosure is key, and I think pre-GDPR we were perhaps a little bit relaxed on this. Obviously, the ICO for a long time have been beating this drum, but GDPR was obviously the mechanism that they then used to really make sure that people are taking it seriously with the fines that can be imposed. But the point is that as long as you're disclosing where you're going, there's a principal difference between my mate Francois giving his data to a French company and that French company shipping it to the UK or shipping it elsewhere to North America, and Francois himself giving it directly to over there. So, for example, Facebook in its sort of pure membership form, I know where Facebook is. I submit my data into Facebook willingly, knowing that that data will live in North America. Now, it's then not fair when it then does things like sells data, and I'm sure Facebook have done some wonderful things to get around this. But the point is, I've committed my data to Facebook, knowing where they are. So that transparency is absolute key. And I suppose one piece of advice that we'd have for all of the attendees today is just have a quick audit and make sure that you're being as transparent as possible within your policies, your privacy policies, and any other policies that we should do. We need a transparency policy. Where does that live, Philip? That's probably a question for you.
Under GDPR, it's Article 5, and it says we must do things in a transparent and clear way. You should actually say, so part of that is just a code of practice. So if every privacy policy should actually say where data is stored. And that's the key thing. And if it's stored outside the EU or it's stored moving forward in the United Kingdom, that needs to be clearly stated.
Okay, the
other thing that you should look at linked to privacy policies are cookie policies and what cookies are being used. The easy thing that everybody does, unless they're a privacy geek like me and Philip, is they just sort of accept all cookies. Yeah. I always go and check what the cookies are and switch everything off apart from restricting this.
And I bet no. In fact, can we have a little social experiment here, guys? Everybody back at home, I'm going to ask you a quick question, and I want you to put into Q&A. Can you please just answer this question in the Q&A? So find the button down at the bottom. I need a yes, no answer. Where is Q&A? It's down at the bottom. It just says Q&A. Yes, no answer. Do you care about cookie statements, or do you just click no? You just click get off my screen. Do you care? Yes. No, I don't care. No. Can we have some answers? Yes, no, yes, no, yes, no, yes, no, yes, no, yes, no, yes, no. No, 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 no. Yes. Oh, well done. Yeah, no, yeah, no, 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 no. I think, you know what? I care, but I don't have time to read them. I agree. But now I think I should. Yeah, no, you know what? Usually no, I'm exactly the same. And you know what? I think this goes back to what I was saying before about webinars. Are people bored of webinars? Are they bored of crap webinars? And I'm bored of crap cookie policies. Why is it every time I go to the BBC's bloody website, they ask me if I'm cool with cookies? Just keep a cookie that says I'm cool with cookies, and then I don't have to keep rechecking it. It annoys me. The BBC is probably one of the worst offenders. And actually, do you know what? I think we as consumers do have to, we do need to place a little bit of faith in the organisations, and it is on us to be a little bit more considerate as to where we are reading our news and where the websites that we are going to. The internet is the wild west. I get that, but if an organisation genuinely is asking you for their consent, and it's somebody like the BBC, do we need to read it? Are you bothered about that, guys? Or are you not bothered?
Not so much, but there's lots of, like, some odd sports websites and sports gossip and all those kind of things. I do look at those and think, oh no, I don't want that. I don't know who they are. I'm interested in that bit of clickbait about what else is doing, but I don't know who you are, so no.
But Adam, it's almost like reading when you get a new phone. You sign a contract, you actually read the terms and conditions in there. No chance. Because you just want the mobile phone, and if you read them, you wouldn't sign the contract.
I've got calls to make. I'm not going to read it.
Exactly.
Right. Anyway, okay, let's move on. I want to talk about the adequacy decision. So I'm going to ask a question again. Firstly, I'm going to ask a yes/no answer again for you guys at home. Do you know what the adequacy decision is? If you don't be ashamed. Not a lot of people do. If you don't, put no. If you do, put yes. And then I'll guide yes, no, nope, 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 nope. Oh, there's an overriding nope. Nope. So we're nope. So we're fairly confident. Okay, so the adequacy decision. Let's have a quick talk about the adequacy decision. So we have discussed adequacy before in previous webinars, so we do need to be quick on this one. But so Philip, do you want to give us what adequacy is? And bearing in mind, as part of the EU, we are deemed as adequate. North America isn't adequate. China isn't adequate. Australia isn't adequate. Somalia, I'm picking on Somalia, probably isn't adequate, I assume. I don't know. But talk about the UK EU adequacy decision for me, please, Philip.
Okay, well, we don't know what that decision is. We think it's linked to the trade deal, but of course it shouldn't be. So effectively, adequacy is where the EU or the Commission look at a country and deem whether it meets adequacy or not. At the moment, 12 countries meet adequacy. Some of those countries are quite interesting. Uruguay meets adequacy. Australia doesn't. The United States doesn't meet adequacy. But Japan does, and South Korea is currently in talks to get adequacy, which will become the 13th. The United Kingdom will become the 13th or 14th, but it's down to the Commission to say whether our laws meet adequacy. So basically what it does a series of tests, and one of which is there a rule of law? Is there an independent judiciary? Do individuals have rights, and can they enforce those rights? And of course, we all know in English laws, Paul and I know, that that's obviously very much the case here. So in theory, we should sail through adequacy. But we also know that politics are involved, and it's possibly tied into a trade deal involving a dispute over fishing, state aid, and lots of other things that the UK and the EU differ on. So this, I don't think, will fold out until possibly even the end of December, and it leaves a lot of It leaves a lot of companies in limbo.
So let's think about that for 1 second. Okay, so we've all in the Brexit negotiations heard about these damn fishery borders and the policies around the fisheries. Fishery in the United Kingdom is worth about £100 a year. Oh, well, I'm being a little bit flippant there. But, you know, I wonder how much is it?
It's a few billion. I think it's about 3.5 billion, but I may be wrong.
All right, not much more than £100. And the point is that you think about the impact of the adequacy decision on the UK, and you think about the size of that debate in comparison. And yet, hold on. So we've been part of the European Union, meeting adequacy, following all the rules. We've by the letter duplicated what they've had. We have the ICO, which is the governing body. We have all of the things in place and have done for years. In fact, we were one of the instigators of the original Data Protection Act, which, what was it called after was it the First World War or the Second World War, Philip?
The Second World War, European Convention of Human Rights, Article 9.
Brilliant, brilliant. So we were there. So if we were for any reason to not meet adequacy, there could only really be a conspiracy slant on this, you know, which is obviously my angle on it. I've got to believe in the conspiracies. And so the point is, we don't yet know whether the UK meets adequacy. And so what that means is that if we meet adequacy, we don't need to have SCCs to deal with Europe. It all goes away. We're adequate. There is a legal framework on our behalf that says happily ship data, as you do right now, to Europe, anywhere in Europe, and any of our other adequate countries, as you've already mentioned, South Korea, hopefully soon, Japan, Uruguay, Canada, wherever. So we will be able to transfer data to any of those countries as soon as we meet, well, no, actually, not as soon, we can do that now, but as soon as we meet adequacy post the 31st of December, we will not need any SCCs for UK to EU data transfer. And that's a big thing. I think that's very important. So right now you don't need them because we're still technically in the transition period. And if the adequacy decision goes ahead before the 31st of December, then obviously we're all good. But if it goes ahead after that, the ICO have given us an interactive tool to enable us to get SCC signed. And, you know, I know for one, Force 24 will make a department that handles this for you. We will say, Philip, you got any more time? No, we will create a department that handles this for you, and that's part of what we do. But I think it's kind of scary because we there's so much unknown. We're still sat in this position where we don't know what we're supposed to be doing, and yet the date is racing towards us, and we're in a bit of a dark place with it, or so it would seem. Guys, is there anything from a point of view that you want to fill us in before we go into questions? I'm just reading through all of the provocation notes.
I think the only thing I would say, there's 12 countries that have signed up to adequacy. 11 of those have already stated that, as far as they're concerned, they consider the UK to meet adequacy. Now, bear in mind, these are not EU member states. These are countries like Japan, etc. And they've deemed that we will meet adequacy, 11 out of the 12. So that's a really good start.
We've got mates.
Yeah, we've got mates.
We've got mates. That's the main thing.
Some of the mates aren't trusted, like Australia.
What about you, Paul? Is there anything you want? I'm just, like I said, I'm flicking through the provocation question. I know there was a point that you made about the where was it now? 101 complaints. Anything else you want to bring up before we go into the questions?
Just to keep it out, although there is that tool on the ICO website. The European Data Protection Board are due to publish new SCCs before the end of the year because the current SCCs are actually really obsolete. They've been around since 2010, and they're not actually up to date with GDPR. So which is bizarre, really.
So what that means that we're going to have to do this all again. So people who've got the SCCs in place now, we're going to have to do it again.
Yeah, probably.
Oh my God.
People wouldn't have a job, Adam, if they kept all these forms.
Oh my God. Well, you know what? Good job that we're based in the UK and we don't have to worry about this just yet. Hopefully we see and everybody's all good. Right. Okay. I'm going to go into some of the questions. Now, firstly, I have got live questions that we've answered. Would there be any new data laws or legislation for public service companies, or would there be business problem? So we've got somebody that's asked a question. This is live. Would there be any new data laws or legislation for public service companies, or would these still be the same as private companies? Yeah. So is government in any way, or public organizations, are they in any way exempt, or is there any kind of protection for these organizations, or are they in the same boat that everybody else is in?
Yeah,
Okay.
Broadly, there are some differences. Some things that that local authorities and government bodies can't rely on, legitimate business interests and things like that, they can't rely on. So there are some differences, but broadly it's the same.
I think it's fair to say some of them are covered off, particularly, for example, the police are covered off by the 2018 Data Protection Act. So there will be, and that's going to be incorporated into the UK GDPR. So some of those things will change. The courts is another example, of course, which are covered by the Data Protection Act 2018. Again, that will come into the UK GDPR. So some of those things will change, but broadly the same. I think the main thing is GDPR, by and large, applies to not just businesses, but charities, the church, any basic organisation beyond a sort of a very personal, if you like, membership organisation.
Okay. Amanda Evans, it's like Eurovision. Does anybody like the UK enough to vote for us for adequacy? She's got a yeah, it's Eurovision all over again. Okay, so if we have an SCC but we don't get adequacy, will we still be okay? So an SCC overrides not having adequacy. I think the point is you wouldn't need an SCC if we met adequacy, so that would be okay. Is what I'm believing.
The point is, Adam, though, it's a fair point that the individual's making, because if we don't get adequacy and we want to import data from Belgium, for example, or Germany, we will need to put in place standard contract clauses just for dealing with someone within the EU. Yeah.
Unless we are collecting the data on UK soil and are disclosing that that data is being collected on UK soil. Right. So the individual has the right to not do this. I wonder, you know, because you've got some, you know, when you fill in a competition, you've got to give them the right to opt out of mailing pro. You know, you say enter our competition and you can win a free car. And actually what we want you to do is we want to collect your data. Yeah. And you know, but there's a little tick box that says, yeah, but I don't want to be a part of anything. No. I wonder whether we'll get to a point where you can put your details in, but I do not want you to store my data on your British servers for more than 12 days or something like that if we didn't meet adequacy. Who knows? But the thing is, we will meet adequacy. Amanda, this isn't exactly the same as the Eurovision Song Contest. We actually do meet adequacy standards. We've got everything, all the boxes ticked. There's just going to be a little bit of a dance just before the 31st of December, before that, just as was the trade deal, and then pretty soon after that, we'll be golden. I'm certain. But if we're not, we're SCCing it all the way. Okay, so. University, Louise, what about universities with a large number of international students? Well, I think, guys, what we're saying there is, you know, that the student has elected to give their data to you. Right. And, you know, the University of Leeds, I'm pretty certain I know where that university is, unless it's the Leeds that's in Kent that always comes up on SatNav. But you know, the point is, you know, I'm volunteering that information, right? Is that's what we're saying, guys? Okay. Any more on the live Q&A before we go into the pre-registered ones? We're good there. Okay. Right. Philip, what do I need to know about similar laws in other regions such as APAC and Middle East?
Well, how long have you got? So according to my last count, there's 47 countries roughly in APAC. That includes Australia. It includes China, Fiji, and a whole host of others. And then there's also touched on the Middle East. So some of these countries do have data protection legislation in place. The difficulty is these countries vary. So nowhere in the world has got anything quite like the GDPR that Europe has, which is extremely thorough. I think 99 articles running through there. So no one else has got that level of protection. California gets near, and they have consumer protection law, which regulates, believe it or not, data protection, but at a state level. So what you need to do, there are organizations out there that can help you, because I can't possibly go through 47 different countries, but there are people out there, and I wrote down actually in anticipation of this question coming up, and there is an organization out there, and it's called, which I will put on in a minute on the Q&A, it's called incountry.com, and they will advise you on every country in the world in terms of their data protection if you're looking at sending stuff. But what you can't do is have one size fits all. So just because you comply with GDPR in Europe doesn't necessarily mean you comply with the state of California or the state of Israel. So it does vary from country to country.
Okay, and here's an interesting one. This will probably play to your strengths again, Philip. Actually, I'll find one for you in a second, Paul. Don't worry. Will Brexit be affected by COVID-19? Brovid-19, we should call it. Yeah. Will it be affected? Is COVID a problem?
The honest answer is the government say no, but the reality of it is that with remote working, civil servants not based in London but working from home. My son's working from home at the moment. He's a civil servant. So the reality of all this, it is having some impact, but the government will say everything remains on course. And that they're on schedule to deliver Brexit at the end of the year. But they've also been clear to the Commission to say they're leaving. So COVID-19 or no COVID-19, this country leaves the EU on the, well, we've left already, as you rightly said, but we actually leave in terms of regulations and following through every EU regulation on the 31st of December. Now, what happens after that will depend on how well the talks have gone.
I'm frantically looking here because I actually did download an article to say that it is possible to extend that deadline. The government have ruled that out. The government's been clear. The Prime Minister has said they are not going beyond that time period. What could well happen is, and this is a talk in Whitehall circles, that actually they don't reach a trade agreement, but they actually continue in sync for another couple of months. And there's also another story doing the rounds that actually there'll be all chaos in January, and there's people who want that, and then the EU, as much as the UK, come to the sense and realise why they need a trade deal. Right, okay. High risk stakes.
It was today was supposed to be that there's a European Commission meeting today, and it was supposed to be today that decision was made as to whether there was going to be a deal or there wasn't going to be a deal. They are not near enough to be able to make that decision, and the talk yesterday was that it might be put off to the next Commission meeting, which is sometime in November. That's the recommendation that David Frost, the chief negotiator, is making, apparently. So it's going to be, sounds like it could be kicked down the road a little bit further, but we haven't got long.
Well, let's see, Let's see. One question that we had is the implications for B2B marketing, and it's quite an interesting one. I mean, what I think we've got to understand is that we're not going to see another shift. Well, we shouldn't see a shift in permissioning. This isn't about, GDPR actually reclassified and redefined and made us understand more about permissioning, even though it was actually the PECR that held the regulations around those permissions. But I don't think from a B2B perspective, you're going to see any sort of change in the way you do business unless you're dealing with European organizations. And we've already touched on what is personal information. We've already touched upon the premise of transfer of shipping data, and we already sort of understand where we are with things. But Mark from BMW has asked, how do you think manufacturers and retailers coordinate their communications to their mutual customers? So that's an interesting one. So manufacturers such as BMW need to coordinate their comms with their European-based dealers and retailers, and they then need to convey that message out to the public. So it's do we think that anything that we've said sits outside what's been suggested by Mark, or do you think that we've answered that? Paul, do you want to take that one?
Not sure quite what that's getting at, to be honest.
Well, you've got two hops, and what's the relevance of those two hops? Is that making things difficult, or is that an issue, or I think the thing is, we're not saying here it's about talking to people. You know, you can't. It's not that you can't pick up the phone and ring Francois anymore. You can still do that.
Yeah, I think. Well, broadly, as you were just saying, what came in with GDPR and the greater awareness and greater discipline around how people use communications and so on, that still applies. So that's not going to be thrown over at all. So that is still the case. So I don't think we're going to see anything on that side of things.
So what about Microsoft? This is Amanda again. So most UK businesses are using Microsoft Outlook, email for putting the data, Excel spreadsheets. Can we no longer use Microsoft Post? And again, you know, Amanda, the point is, if you as a consumer have gone on there and you've used Microsoft willingly, knowingly, and downloaded their products and given them your consent for your data to use their products. The difficulty is when you're shipping that data to a cloud platform and it's got customer information into it. So Outlook now, I think you can, is it called OneDrive or whatever? It can automatically sync to the OneDrive function. You know, that actually from a GDPR perspective is a bit of a nightmare anyway, because don't forget, you've got the right to erasure. So the thing is that what you've got to be able to comply with is the fact that if somebody says, get me off your systems, you know, you've got to go through these steps of removing these people anyway. So you've got to be careful when you are holding contact data on Excel spreadsheets anyway. You know, you email that to somebody. Here's what happens when you, so firstly, I create a file and I've got some of my customers' records on it. And I say, right, I'm going to email that. I save a copy into my Outlook. So that creates a little temp copy of that file in my Outlook. I then hit send. It then delivers that and it creates another copy and saves it into Philip's temp Outlook folder. He then downloads it. It creates another copy on his desktop computer. That's 4 copies. And then he saves it again because he wants to make some changes because, you know, he doesn't want to mess the original file up. And then he emails it back and all the cycle goes again. So anywhere you are using Microsoft for that kind of thing is look, well, not Microsoft, but, you know, any kind of spreadsheet or anything, you just got to be aware of that audit trail. And it's massive. And it's, generally speaking, platforms like ours allow you to manipulate that data in the platform. You know, the CRMs, they allow you to manipulate the data in the platform. So you do your slicing and dicing and your reporting, whatever you need to do in the platform, so you don't have to create this mass log of you know, data that you've got. Yeah, so I use CRM, but they're usually American, except yours, and we need to chat, obviously. Right, yes, of course you do, Amanda. Yes, come and talk to us. I think, what does the future of GDPR look like in 21? I think we've probably answered that. It's going to look very much the same. There's loads of really great questions here. There's loads. It's so difficult to. Oh, there's more. Oh my god. What if I remove? What happens if I remove someone and they appear again in my new searches? How do you forget a person permanently without storing their information? This, you know, I mean, this is basically what the question that's being asked here is, how do you remember to forget somebody? And that's always been a classic debate, isn't it? It's how do you remember to forget somebody? And that's a really, really difficult one. And one of the things that, you know, guys, this is kind of a little bit off topic here, so I'm going to be quick on this one. So one of the things that we actually had a long discussion with the ICO on this one, a long discussion, actually, I say a long discussion. We spent a lot of time trying to talk to them and then actually getting one word answers back from them. But you know the ICO and how they work. We finally got a yes answer on, okay, if we take an email address and you say, okay, I want to be deleted. What we do is we delete that record and we don't encrypt it, we hash the email address. Hash is so an encryption means that once you've encrypted data, it means that you can decrypt it. So it's basically, I've got a key, Philip's got a key, Paul's got a key, I send the emails. The only person that can see that data is Philip and Paul. Whereas a hash is different. A hash is where I take Philip's data and I throw it into a random set of whatevers. You cannot ever decrypt that to get Philip's data. But what you can do is if Philip comes again and I hash that, I can compare that with my hash that I made when I deleted him. So the ICO have recognized that a hash is not personal information. So what we do in our environment is when you hit the button to say erase, we hash the value. And when any new contacts come into our environment, we also hash them and we check it against those deleted hash values. And the thing is, that's a massive engineering challenge. And I don't think many people have gone anywhere near the level that we went through to get to that point. But that important distinction, anonymous attendee, is a hash versus an encrypted value. I know this webinar isn't necessarily about that, but I do know the answer to that one, so that's fine. Guys, anything else that you want to add before we end for the day?
The only thing I would say on that with regards to Amanda's question is quite simply this, that you are entitled to meet your legal obligations, certain bits of data. So to meet the right, so you don't actually contact that contact again because they've had erasure, you can keep the record so you can meet your legal obligations, because if you didn't, then you'd be committing an illegal act in terms of reaching out and contacting them.
So we discussed this with the ICO.
Yep.
And they said, but have they asked you to delete it? Yeah. So you should delete it. Okay. But how do we remember you've deleted it?
Yep, I remember the debate.
Well, you store a record. And that was the whole thing about the cookie policy, if you remember. It was like, how, I ask you, do you want to store cookies? And you say, no, don't want cookies, no cookies. Well, then the next page you look at, I have to ask you again, unless I store a cookie to say that you said I don't want cookies. So it was like this whole pointless argument. Like, no, think about it. Is it okay that I store this one cookie that says it's cool not to remember cookies? Yeah, it's cool with that. Yeah. Anyway, listen, guys, thank you very much for your time today. Philip, why don't you give us a quick 10 seconds why somebody should go and talk to you right now, and a very quick sales pitch, and then Paul, up to you, and then we're done.
Right, very good. So I support various clients, both in the UK and overseas, including Force 24. If you've got concerns about your data protection, and particularly next year, come and talk to me. You're always welcome to have a free discussion. We won't charge you for that. If you need an audit, we can do an audit to check that you're going to be compliant and tell you what you need to put right. And if it's a complicated form, we'll refer you back to Paul. He'll be very happy, no doubt, to draft the form for you.
Thank you. And Paul?
Yeah, well, following on, thank you very much, Philip. And really following on from that, over and over and over again, as I said earlier, we see privacy policies which are just templates. They don't really reflect what people are doing. And so if you want to be protected against fines and investigation and so on, that you have something that is really transparent, that's really specific to what you do, and where you, if you need consents, takes consents, is really important. So that is part of what we do. But don't just rely on the template. Don't rely on a web developer to give you something. It needs to be your thing. And there are tools out there to do that.
Thank you very much, chaps. And obviously we're Force 24, so come and chat to us, email, SMS, marketing automation generally. We're here in the UK and we're happy to help. So force24.com, go and have a quick look. But thank you very much for your time, guys. And thank you everybody at home for listening. And it's been great. We will send round recordings for those of you that only caught half of it, or those of you that missed it altogether. And I'm talking to you in the future. That brings your mind, but never mind. We'll leave it there. So thanks a lot, guys. See you all on the next one. Take care.
Okay.